students. Hope you all are healthy and safe. I am Sony Pardeshi and today we are going to start lesson number 6 part 2. First part already we learned about women empowerment. Different issues related to women, their problems, and we have seen to solve these issues and problems there are so many women's organizations were established in India, as well as their functions to solve these all the issues and problems of a woman. And in the second part of the lesson we will learn laws for women. The law enacted in 1952 recognizes women's right to alimony. Alimony means the amount which should pay by the husband to the wife after their divorce or separation for her maintenance. The main aim behind it to provide her financial support, as well as their share in the father's property. Her right to Stridhan was recognized. Polygamy was made illegal. Polygamy is the practice marrying multiple spouses. Polygamy was made illegal and women just like men got the right for sue for divorce, means separation. The Dowry Prohibition Act of 1961 made both giving and taking of dowry a recognizable criminal offense. Cognizable means the officer can arrest the criminal or the convict without a warrant and start the investigation without a permission of the court. This dismantled the dowry tradition by its roots and further encouraged the social movement. The law alleviated the distress to women caused by the undesirable tradition of dowry. The Maternity Benefit Act, which gave women the right to get leave from work of the time of childbirth, also came into force in 1961. Awareness against the dowry tradition. Even after the enactment of the anti-dowry law, incidents like women burns to death as sari pallo catches fire while cooking and women slip into well while washing clothes, drowns and dies continue to be reported. The role of the police, the administration and judiciary were highlighted. This created greater awareness about the dowry. As a result, the Dowry Prohibition means Amendment Act means changes in that particular act came into force in 1984. In 1988, 2,209 women died victim to the dowry tradition. In 1990, the number of dowry deaths was 4,835 and in 1993 it was 5,377. These numbers will impress upon you the seriousness of the dowry issue. Family Courts 1984. This family court was a part of the trends of the legal reforms concerning women, prevalence of gender-based laws and oppressive social practices over centuries have denied and just gave the basic rights to women. The main aim of setting these courts to take care of cases dealing with family matters and away from the atmosphere of the regular courts. Family courts were established to resolve conflicts arising out of differences within marriage and domestic problems, as well as issues such as alimony, single parenthood, separation, care of children, and ownership, which are all related to the family situation. These family courts give priority to mutual understanding over witnesses and evidence and to counselors over lawyers. Emphasis is on resolving issues quickly but justly. Trial involving alimony 1985. Students, already we learnt alimony means a fixed amount paid to a married woman for upkeep by the husband who has divorced her. It is called alimony. In the case of Muhammad Ahmad Khan versus Shah Bano Begum, the Supreme Court gave the verdict that Shahabano Begum had the right to alimony. However, religious organizations protested vociferously, means very strongly, against the verdict. As a result, the Muslim Women's Act, Protection of Rights on Divorce, was passed by the Parliament. Commission of Sati Prevention Act. Sati means a former practice in India whereby widow threw herself onto her husband's funeral pyre. In India, before independence, Rajaram Mohan Rai opposed the practice of sati, and in 1829, Lord William Bentinck, who made the sati illegal all the part of India. But on 4th September 1987, Roop Kaur, a married woman, committed sati. She did not do this of her own free will, she was forced into doing so. Committing sati, glorifying the practice of sati, were all illegal acts. Women activists and journalists Meena Menon, Geeta Seshu, Sujata Anandan, Anu Joseph, and Kalpana Sharma investigated the case. In 1988, the government passed the Sati Prevention Act with very stringent provisions. Protection of Human Rights Act. In 1993, this law was enacted to prevent injustice to men and women. The National Human Rights Commission was also formed for this purpose. In some states, the State Human Rights Commission was also formed on the same lines. This law, which deals with collective operation, the social conditions of divorced women and secure workplaces, played an effective role in mitigating injustice to women. Reservation for women. The 73rd and 74th Amendment to the Constitution provide for reservation of one-third of the seats for women in Gram Panchayats, Panchayat Samiti, Jilla Parishad, municipalities and municipal corporations, as well as for the post of Sarpanch, Chairman and Mayor. Maharashtra and 15 other states have reserved 50% seats for women. This provision provides women the opportunity to participate in the business of the community. In the post-independence period, the Constitution of India accepted the principle of equality of men and women. Women got equal rights to education and work on par with men. Hence, women got the important political right to vote. Inhuman practices like sati, dowry, and polygamy were banned by law. Women's right to sue for divorce was recognized. They got a lawful share in property. In local self-government bodies, seats were reserved for women so that they would have their just share of political power. They have begun to participate enthusiastically and with determination in all fields of education, earning money, administration, politics, etc. Due to ideas of women's liberation, we are developing a sense of self. We see today that due to these provisions, women have begun to get education and to earn. Now, we are going to see the weaker sections of the society and what measures did by the Constitution and our government. Do you know Women Chief Minister in India? Sucheta Kriplani, Uttar Pradesh; Nandini Satpathy, Odisha; Jay Lalita, Tamil Nadu; Mayawati, Uttar Pradesh; Vasundhara Raje, Rajasthan; Mamta Banerjee, West Bengal; Rabdi Devi, Bihar; आनंदबाई पटेल गुजरात; शैला दीक्षित दिल्ली; महबूबा मुफ्ती सईद कश्मीर; उमा भारती मध्य प्रदेश; राजेंद्र कौर पंजाब; सुषमा स्वराज दिल्ली; शशिकला काकोडकर गोवा; सईदा अनवर तैमूर आसाम; जानकी रामचंद्रन Tamil Nadu, and all women who have led their states as chief minister. A demonstration was held in New York on 8 March 1857. It was the first demonstration by working women, and its demands were for fewer working hours, proper remuneration, provision of creches, etc. 8 March 1909, women went on strike for the very same demands. That is why this day was declared as the Women's Struggle Day at the Women's Socialist International Conference held in Denmark. The year 1975 was observed the International Women's Year, and in 1977, 8 March was declared as International Women's Day by a resolution passed in the General Assembly of the United Nations. Scheduled castes. In the post-independence period, our constitution adopted the values of freedom, equality, fraternity, and social justice. In accordance with it, the practice of untouchability was banned by law. Untouchability was removed by the 17th paragraph of the Constitution, and this class was included in the scheduled castes. In view of the educational and social backwardness of these castes, they were given reservations in education as well as jobs to facilitate their development. Now, why were they given reservations? Because these people were educationally and socially backward. Their earlier generations were not allowed right to education and not getting opportunities and status in the society. So reservations are there or some seats are reserved for them, it will definitely step ahead. And they can also do the development for their society. Scheduled tribes. Just like the scheduled caste, the scheduled tribes or Adivasis who live in remote parts of the country also face several difficulties. As they have lived far away from the progress made in modern times, they are economically and socially backward. Even though their conditions have been seen some improvement in recent times, they do not have any means of livelihood other than agriculture and forest produce. Modern farming implements have not yet reached them. Their income from agriculture is very small. Besides, their fields are on hillside and not fertile. They are malnourished due to insufficient and poor quality of diet. Adivasis in remote areas find it difficult to get medical treatment or attention in time. For all these reasons, there is a need to give special protection to Adivasis. In the Indian Constitution, Adivasis have been enumerated as scheduled tribes. They are getting and given representation in law boards, education, schools, colleges, government services, etc. And then next weaker section is nomadic and denotified tribes. Castes and tribes that move from place to place for a livelihood are included under nomadic tribes. They live by rearing animals and engaging in some other occupations. The British had declared some of them as criminal tribes. In the law of 1871, to curb crimes, some of the main groups were mentioned as criminal tribes and their occupations and movements were banned. This unjust law was repealed in the post-independence period and the curbs on these tribes were lifted. They were included under denotified tribes. Special efforts are made by the government for the purpose of their social and economic development. These tribes have been given representations in educational institutions and the government sectors. The last weaker section, that is minorities. Minorities means in any society, a group of people of particular religion, language or race who are few in number are termed a minority. In India, you can see that mostly the Hindu peoples are there, religious peoples are there. So other peoples of other religions are known as minorities. As there are various religious sects and languages in our country, we see great cultural diversity. There is variation in cultural traditions too. In order to preserve their cultural traditions and develop their own language, the Constitution gives the citizens certain educational and cultural rights. Minorities have the right to protect and conserve their language, culture, and traditions. For this purpose, they have the right to set up separate educational institutions. The government implements various schemes for their progress. So students, in this lesson we learnt some laws which made by the government or some constitution provisions which are particularly for the upliftment of women as well as the weaker sections of the society. Thank you. Stay safe and healthy. God bless you.